genesis behind these forums that we've been doing is that we wanted to gather a lot of the great legal minds in this area and get people together to talk about some interesting topics, but more about the business of law than that really awesome First Amendment case that nobody cares about. So we have gathered some great panelists, but we also have a lot of great people who have been coming here. And part of the format is that we have our panelists introduce themselves. They talk about some of the key points from their point of view about the topic at hand, and then we turn it out over to the audience to ask questions, to give their input on those topics as well. So we really want your participation. We did this last fall, had an excellent discussion. I think with the group of attendees here and who's registered, that this could be a really, really interesting conversation. So really looking forward to seeing how this evolves. This first topic, last time we scheduled it for only 30 minutes. We had to let it go for an hour and 15 last time because the discussion was so great. So really looking forward to seeing how this goes. Before I introduce our panelists, I just want to set the stage a little bit on the legal, kind of the state of the legal industry. So if you didn't see this, at the end of August, Archer Norris, a 70 lawyer plus law firm, 4 offices in California, filed for bankruptcy. We have those big elite law firms. Apparently demand is up for them in 2018, but everybody else, demand is flat, capacity, productivity is down, realization's down 10% since the Great Recession. So it used to be at 93%, it's now at 83%. Rates for law firms have been going up. So what that means is demand down, productivity down, but rates up. So profit margin for law firms in general, right, is flat. Law departments, 68% of law departments are looking to add, or were looking to add lawyer headcount in 2018. 36% of those were specifically to reduce outside spend. That's according to the Altman-Weil survey that came out in the end of 2017. Law departments are looking to increase efficiency, and they plan to do so through technology. And technology is increasingly impacting the legal profession and how work gets done. We've got issues about retention of female talent. We've got the de-equitizing of lawyers, which is what's gone on since the Great Recession. And everybody, whether you're a law firm or a law department, you've got the mantra of do more with less. So the last thing I just wanted to mention was from our own Legal Market Outlook survey in 2018, which we're going to get the results out here soon. Law departments suggested for law firms to increase demand for their services that they should focus on increasing operational efficiency, invest in new technology, and focus on core services. We asked a similar question to law firms of themselves. What are they doing to respond to this decrease in demand? And their response was to increase marketing, followed by a focus on profitability and operational efficiency. So law firms are getting, it seems like they're getting some of that message, but I think where law firms could really do themselves a favor is sending out client satisfaction surveys, asking what are they doing well, what could they do better, and where would their clients like them to focus their investments in the upcoming years. So with that, I want to introduce our panel for legal industry pressures. We have Hillary Rule from Eaton, Teresa Ann Gilbert from Lubrizol, Dave Kupar from McDonald Hopkins, and Doug Miller from Sutter O'Connell. They have seated themselves, boy, girl, and also in-house and out-house. So well done. We didn't even ask you to do that. But, so we're going to start with Hillary. Please introduce yourself, your background, and then give us your key points.
Everybody else brought cheat sheets. Okay, so I'm already behind it. I'm trying to open it up on my phone to see what it was that I told you all. Hi, you guys. Thanks for being here. I'm Hillary Rule. I started out as a litigator a gazillion years ago, as a bankruptcy litigator with Baker and Hostetler. Was there for a number of years. Went in-house as a litigator to TRW. I was the last TRW hire before we were acquired by Northrop Grumman. Chose not to move to Virginia or California and ended up at Eaton as a litigator. And then about 10 years ago, made a move. I was working with one of the generalists at Eaton, and he asked me what would it take to have me move over to the business. And I said, no problem, I'd love to. So I became the generalist for the aerospace business at Eaton and have been for a long time. That kind of is a loaded statement sometimes if you read the newspaper, because the aerospace industry, aerospace business at Eaton has had a, somewhat public persona over the last couple of years when it came to litigation. I was not part of any of that, I will say, but it is...
Hillary, in corporate speak, we call that OFIs, right?
Okay,
Opportunities for improvement.
I'm not really sure. I always said that when I was looking out at a group of lawyers saying what my role was, all of a sudden I realized, oops, not to distance myself, but I was not involved in that. But yes, so I'm in a generalist role, and did you want me to go right to what it is that I'm supposed to speak, or is he supposed to introduce himself?
Please.
Okay, Jeff asked us to give a couple of points about what it is we think, the pressures we're facing, what we want from outside counsel. And having been in a litigator role, and also outside counsel, and also in-house, and also now moved into a generalist role, there is a very distinct difference between what you need to give, and what attorneys need, depending on the role they are in-house. And I think everybody needs to be aware of that role. And I know Charlie's here from Eaton, and he has a very different role within the law department than I do, and could, speak to very different demands on him and his time and his budget. With me, and as in general, we touch everything that the business can get themselves into before it gets basically to litigation. There are specialist practices that we can go to for help, but we are the first point of entry to anything that's going wrong. So commercial disputes, supplier, customer, regulatory compliance, anything, HR, all start with us. Because of it, there is a speed and a cost efficiency they want. So many questions bubble up that they just need quick answers. In fact, it turns out often it doesn't even matter if it's the right answer. You just need an answer so you can move forward and adjust and just keep moving forward and not slow the business down. They don't have the time for you to go and do an exhaustive research project. They don't have the time for memos or any of that stuff. So I have very, very huge demands on my time. I often have very few facts to deal with. So the interaction with outside counsel can be a tension, because outside counsel being, and I appreciate that role, you want more information. You don't want to commit malpractice. You want to be able to give a complete and thorough answer. And the fact is, I don't have that. Those facts may never surface. And it's only if things go dreadfully awry that this could ever come back. So I really need someone to bounce ideas off of more than I need anything in exhaustive and every 50-state survey or anything like that. So that's where I run into pressures with outside counsel. And I do appreciate the desire for more information, but you just have to be appreciative of the fact that we don't have that. And often, I spoke with Jeff about this. We were talking about, you get a memo from an outside counsel, and you're desperately scrolling through to try and find one piece of information that you can pull out to give an answer to. And they're beautiful pieces of work. It's square peg round hole. And for Charlie's role and what he does within Eaton, that may be what he needs. It isn't what I need. So it's being aware of the time demands, being aware of the fact that I don't have everything, and we're hitting on probably 15, 20 different topics a day. So I just have a short bit of time, and I just really kind of want to use as a sounding board. In fact, my favorite relationship with, and this is not a shout out, but it was a former McDonald Hopkins attorney who I never met. We worked together for 10 years. I was given his name by somebody else in my department as a possible person to work with. Never invited me to a party, never did anything. It was a perfect relationship. I would never have recognized him on the street, but I would pick up the phone and say, I won't quote you, I won't even tell anybody I've spoken to you, but do you think I'm insane with this? This is the two pieces of information I need to have. What do you think about this approach? And that's how it worked. And he retired recently, and it was a sad day for me. But that's what I'm really looking for in terms of help from outside attorney. And the other thing I would look for is just, I kind of mock the memo. Be aware, if somebody doesn't ask for that type of work, don't do it. Or if you think it's needed, call and say, hey, would you like a memo or something? That often happens that I'll end up with something. I never think, because it's not something I use, I never think to tell somebody, don't give me a memo. And they're, again, lovely pieces, but they go into a file and they're very, very, very rarely ever used. So I guess those are kind of the summation. Don't turn it over to you. Is that how we're supposed to go?
Yeah. Yep.
Let's talk fast.
Teresa Ann.
Okay, so thank you, Hillary. That was wonderful. Teresa Ann Gilbert. I am the Chief IP Counsel at Lubrizol. I've been at Lubrizol for 18 years, been in my role about 7 years. Before that, I was, for a short stint, I was a partner at Banish. because I used to work for BP, who left me and went on to Chicago, so I did some law firm work and then ended up back in in-house. I like in-house, I like being in-house because you get to wear the business hat and the legal hat. So the pressures that face us in-house this year, and what solutions are we looking for? So we have a lot of budget pressures. So we had a budget, came up with a budget. I would have said in the past we could always have a variance to our budget. You could always be outside of budget. We had a new CEO come in 2 years ago. You have to live within your budget. And the businesses are even being pushed tighter on making you a lot. They've got to make money. So 2 years ago, we had a reduction of force. I lost an attorney, a paralegal, and an administrator. We absorbed all that work. We were, because lawyers say yes, we'll do it. We absorbed that work. In March of this year, and we do our budgets about now, so our budgets are being set for next year about now. So our budget was set for 2018, and the businesses, we're looking at their future year, and we're sitting there going, well, we don't want to reduce force again, so how can we cut? How can we, cut bottom line? And so they look at the services, and legal's a service. We are always a service. You guys are services, we also are a service. And so I lost an attorney who went to another company, and he went for an incredibly high percentage increase in salary, all these good things. And so I went to my CLO and said, we need to do this work. We reduced people last year. So we put out an advertisement looking for an attorney to work for us as a consultant for part-time, and we got a lot of inquiries, but the data points were such that the prices that the law firms wanted to were quoting me for, one lawyer working 2 to 3 days a week for a year's salary were probably what most of the attorneys in my group would quit and take the job. So, and my CLO was really shocked. She thought, oh, we'll get somebody in for $100,000. It was, and we did it. And so then I looked at her and said, what are we going to do? And I said, we cannot absorb this work. We'll have, a mass, everyone's going to leave because they're not going to keep, everybody's already working at capacity. Everyone is since the Great Recession. So we had to be creative. And so we went out to the 2 presidents of the business, and I looked at the workload that the gentleman who left was doing. I looked at my portfolios and said, okay, we're going to go out to the business and say, you've got to reduce. You've got to cut our workload. And so that, in all of my 40 years of practicing, I have never done that. We've always gone to the businesses and said to them, this is what outside counsel is going to cost us, so you guys are getting a great deal with us. Well, that wasn't working this year. So we did that, and we gave, and we had a lot of grumblings, and we did that. We reduced part of our patent portfolio, basically 1 man year's worth of work. I felt comfortable doing that because I think we hadn't really trimmed it for a while. So I believe there was things that we could get rid of, and once we got rid of that, then we could shift the work around between the other attorneys. My concern is if this happens next year, there's no easy cases that I think where we wouldn't be hurting the, protecting the intellectual property assets of legal. So I think we had those low-hanging fruit. What we do next year, I'm not quite sure. We don't have next year yet. But that was one of the huge, pressures that we felt, is that we couldn't go outside, we couldn't do it inside, and so we had to reduce workload, and we did. And not everybody is still happy with us. Our IP managers and our tech people in the businesses still, who were, good friends of mine, and would occasionally take me out for beer. Don't talk to me this year, but I come up with that. So that was something we had done. We also took that workload and we started to shift it around. We shifted it to other practice groups. We have group counsel models, so we have generalists in each of the business. I'm a generalist in one of our businesses, even though we all have lots of hats on. So we started to shift some of the agreement work around, some of the licensing work around, and tried to get rid of low value work. Another way we tried to stay within the budget was we started to automate things. So we have automated our secrecy process. We did that all in-house. We didn't go out and buy a system, which would have been the easy way to do it. We worked with our IS department, and we automated our secrecy and agreement system. Because, as I said, we lost a paralegal and an administrator the year before. We converted our databases to an online system, and we automated our vendor payment invoice processes. So all of our vendors and all of our agents, and I don't use a lot of U.S. outside counsel, but I have a lot of foreign agents because Lubrizol's portfolio is patented and trademarked all around the world. And so we had to tell all of these law firms, you have to do it our way. And a lot of law firms didn't want to do it our way. And our way isn't the legal way. It is the way all of Lubrizol did this for all of our vendors. It is a global system now. So if you want to be a vendor for Lubrizol, you have to fit into our purchase order system. And we, a lot of law firms in foreign countries didn't want to follow our processes, and so we, I talked to people who really like this law firm. Are we doing really good work? Is there another law firm we can use in that region? And so we found other law firms. So we changed our law firms because they wouldn't fit the Lubrizol process. Because Lubrizol right now, in its processes, there are exceptions. We've always been the company who would do all the one-offs. We are not doing one-offs right now. So that was another thing we did to make it easier. The women who handle all of the invoices now have time to do other work. So we have tried to free up their time so that we don't have to hire more people. So we've done a lot of automation. And the other big thing we're doing, and I think of what Jeff said, is marketing. So why does an in-house counsel market? So we are in the process of writing value proposition statements for our businesses. Instead of just showing them how much cheaper we are than all of you guys, which is I like to do, it's much easier. Now we have to write a value proposition. So what we're trying to do is understand really what they need. Like you should be understanding really what we need. What do they need? If they were building an in-house law department from the bottom up, what would they hire? What would they want? What would they want to protect? And so we are trying to do a value proposition. We've written accountability statements where I have brought them with me. It's like 5 pages, and it's our commercial agreement section, our regulatory section, our ethics, claims, IP. And it states basically who is responsible for what in the corporation. Who makes the decisions? Does legal make the decisions? Does our business partner make the decisions? So we're trying to really clarify things because we're not working, the whole company has, we're not working the same number of people we used to work at. So you've got to move faster, you've got to be efficient, and you make decisions with a lot less information, both on the business side and the legal side. So that's kind of like the pressures that we're feeling in-house, which is kind of some of the pressures that you guys are feeling. So maybe what you're doing can help me do what you do for my clients.
Right, and Teresa, I think kind of what you were covering earlier on about, hey, we went back to the business and said, you got to cut this work because we're not going to do it. There are these work allocation studies that can be done and that you can do with in-house departments and with law firms and make a decision about what do you keep doing, what could you be doing better, maybe it could be outsourced and it could be at a lower cost, and what are you going to stop doing? Because it's just such low value and it's such low risk that, hey, we're just not going to do it. And the other stops along the way where I was an in-house counsel, there were times we went to different business groups and said, we're just not going to do that. So you guys are going to do it.
So Jeff, what we're trying to do is, we don't like the word low value because that's what our CLO does. Let's get rid of low value work. We've been doing this since like 2016. And especially the paralegals, if you take away their work and they say that's low value, so we're trying to find it and say, we're trying to find you to be more efficient. Yeah. So you can do better, more exciting work. So low value, at least in Lubrizol, has become a term that people
you should be telling them they're going to work on more strategic stuff.
Right? Something more for their development. It's really in how you communicate It's that.
It's back to your marketing. It's all about branding, baby.
It is all about branding.
Okay.
I have a question for the two of you, actually. You were talking about, well, you were mentioning it, but you've also mentioned pushing back on the business and do less work. At the same time, you're trying to market your value to the business. I mean, they seem to be somewhat at cross purposes. The other thing is, and having been in the role of a generalist, you can see that so much of the business, I mean, it's based on trust and knowing you're there, and even doing low value work, you know, getting me out of jury duty,
Yep.
low value, but builds trust. I mean, who
Yeah.
hasn't done it?
Yeah,
I
it's a
haven't
fine
yet.
line.
Yeah, I haven't
Yeah.
had to do the drunk driving kid out of cops yet, but, you know, it's all just behind the next phone call, right? But if there is, and it's a partnering and a trust, and if you
Yeah.
cut back on this, they won't come to you. And, you know, so do things not get surfaced that need to get surfaced? And I found each year I have more work, and it's because I've done this longer, I know more people, they trust me, and you start at the bottom and you work up, and now you get those calls. So how do you manage the pulling back, but at the same time marketing?
I think you pull back and they trust you to decide what you're going to cut out of their portfolio of work. But you also have given them the option, if you want us to keep this, they make the decision of what they cut. And so their other choice is always to give us more money so that we can hire more and keep them. So we kind of hopefully try to push some of that decision on them so that we're jointly making the decision together. That's what, I mean, because they're our partner. We are, legal is a partner to the business.
Thanks. All right, Dave Kupar.
So my name's Dave Kupar. I head up the intellectual property practice at McDonald Hopkins. And so just coming, a lot of what Hillary and Teresa talked about are a lot of the things it's interesting hearing that even though I'm in a law firm, they're obviously in legal departments and companies, a lot of the same messaging, you know. So just again, just by way of quick background for me, I head up over 20 people on the IP side. So we handle that. We deal with issues like how do we provide services to companies? What are we thinking about there? How do we make strategic, how do we provide strategic services, not just transactional based services? And then internally, how do we, as a firm as a whole, beyond just what I do as an intellectual property attorney, how do we work together? Whether it's corporate and IP, even real estate and IP, real estate and finance, you name it, how do we work together to provide better value to clients? Literally a lot of the things that both Hillary and Teresa talked about are things that we are dealing with internally, like I said, as a law firm. So, for example, in regards to something straightforward that Hillary brought up, how do we go from a model of memo writing to providing the advice that a client quickly needs in minutes. We've literally created, from an innovation standpoint internally as a law firm, seminars internally on how to write to our clients. We've actually sat down, whether it's paralegals, lawyers, partners, associates, and sat down and talked about what a written work product should look like and how that's different. For those of you who have ever worked with an IP attorney the last 20 years, think about sort of a report out letter, and you think of this lengthy format, this 2-page document. We don't write that. We haven't written that for clients in years as a law firm. Instead what we do is just get to the point. If it's an FYI-based email versus, we actually need your attention, we need information from you. Be very clear, be very succinct, identify the deadline, don't fake the deadline, and also if the deadline's 6 months off, we're trying to avoid sending it out today for obvious reasons. You don't want the skies falling type email. So to your point, I mean, being smart about what that correspondence looks like, the advice you're giving, because you're dealing with people who have very little attention probably, and unless it's very important, you've got to be smart about what type of advice and what you're giving out there. Budgeting, I know that's the next panel. I'm not going to talk about specifics regarding budgeting, but I will raise it from an innovation standpoint, which I think is appropriate for this CLE specifically here. I can't stress that one enough. I think for all of us in this room, some work in law firms, some work in law departments, some of you are alternative legal service providers here. The starting point really, the question's got to be more than ever, what's your value proposition? What are you bringing to your client or potential client? And it starts with that. I think, and fees, deliverables, and timing all have to come into that. And being smart and effective about what you're doing. If you read my bio, I've said this to people, my bio is dead on in terms of what I provide, and what our department as a whole provides. It's just, I think it's an indication of the department. And And we've switched to a model where, for IP, what the service we provide isn't just as simple as you need a patent application, we write patent application. You need agreement, we write, a JDA for you kind of thing. Our model is very strategic. What we look at now for clients, potential clients, is, all right, where are you at from an IP portfolio standpoint? So if you're a company that's got any innovations, what are you doing? Where's your overall business at? What are your goals? And to the extent there's a mismatch there, what we try to do strategically is align that. I mean, that's what we're providing as legal service providers. So pricing, cost, and budget becomes a big deal. So, in the past, lawyers on the outside were reluctant to have those kinds of conversations. What does your budget look like? What's your business trying to accomplish from a monetary standpoint? And helping them, to Teresa Ann's point, and Teresa Ann's doing the exact same thing internally from a law department standpoint, is this is the budget, this is what you're trying to accomplish. We can't fit that in with this current budget, so we're going to have to make difficult decisions. How do we do that? And at the same time, it's not just a cut back where we're cutting across something that's just of significant value, but rather you can actually show value in that cutback process as well. So it's exactly right. I mean, from an outside counsel perspective, we do that a lot with clients. It's not going to be a shocker, but the clients who are doing really, really well and can, they have less of these issues. It's the companies that are facing a competitive environment. They're facing disruption. They have to be smart about how they spend money, where they spend money, why they spend money, and they need analysis, and in that. So we have to keep up from an innovation demand, and I think that's the difference. I think the law firms that are keeping up with those ideas, keeping up with ways to perform that, more and more by the minute, law firms are taking on more of a Six Sigma approach, being disciplined, having a process-based format, not just being sort of legal scholars and experts in their field, but ways to provide those in a deliverable format is a big deal. And one thing one thing that Jeff identified here in a broad sense was kind of an interesting one, because I have a very unique view, and this is more my view than anyone's, was this rise of non-law firms. So some of you are in here, the alternative legal service provider, law departments, and there's sort of the sense of competition almost. I couldn't disagree more with that. I look at all of you as collaborators. That we should be working together to find solutions for clients. It's not a competition thing, So, and I'll give you guys a simple question. It's kind of an interesting one that goes with this. And again, I don't have fear over it, but I think there's a lot of stuff out there being written about it. I don't know if anyone knows this answer, but who's the largest legal provider of legal services in the world? Does anyone know that answer? The big four, which one?
It's KPMG.
Now, Deloitte. 1% of the world's legal services is Deloitte right now, right? So it's already happened. I mean, so in that sense, am I losing sleep over that at night? No, not even for a minute. The point is that I think we can all collaborate with each other and provide better solutions. If anything, too, I think it's an opportunity. I think people get so freaked out by the fact that this is now a consumer-driven model. You just take a few steps back and just kind of look at what's going on in law. It's just a consumer-driven model. The client now has a lot of power and say in terms of what they want. That didn't happen in the past. Law firms did sway and have a lot of power in terms of the services they provided. And because of the limited availability of law, of books, of people who are trained to give that advice, that's what was the rate limiting step. It's just a different model now. And those who see that model and can work with it will adapt well. So those law firms that are innovative, who think like clients, who deal with and provide deliverables consistent with what that client needs here and now are the ones that are going to do well. I'll add one more quick point in this. Two more quick points, just my observations, again, from a law firm perspective. We internally, just to kind of give you an idea of things we're doing as a law firm, is we have an innovation committee. I actually head up our entire firm's innovation committee. And that goes beyond just technology. That is a component, that's a very important component, but it is things like how do we communicate better to clients? What does that look like? How should we be working with alternative legal service providers so that we can work together with them, show that off to clients in a good way to say, hey, we're working together to provide better solutions than maybe others or things you've seen in the past. So we're not afraid to identify anything that could potentially go on the table to clients ultimately to give them better work product ultimately. So that's been a big deal for us as a law firm. And then finally, I'll say this overall, I think that the business of law is continuing to increase. I think over the next 20 years, it's not going to decrease. This is just, again, me talking here. I think it's going to actually increase significantly worldwide. I just think that the service providers providing it might decrease. I also think that how it's being provided is going to be obviously very different than what we're doing now. So those are the things we should be thinking about. And I think if we collaborate, whether we're in this room, on the video, and look for ways we can help each other out, work together, I think we'll go a long way in terms of not just meeting those challenges, but being ahead of the game. Final point, I'll say this about IP specific. I think IP is another one that's going to continue to take off. And with technology, there's just a huge amount of issues. And I'll say this, from like a data breach and cybersecurity side of it, that's a significant practice of ours. So, and it's one that 5 years ago, no one was really even thinking about. And now it's as big a practice in our firm, and as hot a practice as there is in our firm. I mean, we're dealing literally on a daily basis with a cybersecurity issue, in every single industry, including every one of your industries where someone's getting locked out of a server, and we have to deal with Bitcoins. We literally see that on a daily basis. In fact, I was mentioning to someone recently, one of our clients actually has a Bitcoin account, and they're ready for that under cybersecurity as part of their data breach plan that we help put together for them. So, you're seeing, again, it's just an example I just wanted to raise to each of you how the law keeps expanding. IP expands in and of itself as a subset in that area. To Jeff's point, there might be some flatness short term with law firms, but I think that says more about the management of law firms and maybe not being innovative and not meeting those demands, and quite frankly how they run their law firms internally than where the state of the market is. I think the market's a significant one. I still don't think we have met those challenges, and I'll say this from sort of a technology side. I don't think Silicon Valley's gotten into it yet enough either. I'm just surprised by that. I think some of you are in here are technology providers to law departments and law firms. I'm just surprised in a way if maybe Silicon Valley just doesn't see yet the opportunities there. They're still going at autonomous driving. There's other irons in the fire they're working at. But I think the legal services business is one that I think where when you get big technology providers and big money involved, there will be a lot of solutions. I think that's where this thing's going to take off to another level. So anyway, just my thoughts. Some of the things we're doing as a law firm, how we think about it as a law firm, how I think about it as a lawyer. From the outside, in a law firm, in terms of what we're providing, where we're at in this day and age.
Thanks, Dave. All right, Doug.
So my name's Doug Miller. I'm the CFO for Sutter O'Connell. I'm the senior admin person in the firm. And maybe because we're a litigation boutique firm of 20 attorneys, we have a little bit of a different perspective on things. First thing that I think of is that this perception of fungibility. There are times that I think clients, especially larger entities, kind of believe that all attorneys within a practice group are fungible. Okay, well, they all have the same skill set, they all do the same work, they get the same results, and so really at times it feels like, I think from a lot of firms, you get this thing of, it's the Walmart thing. Well, who's going to give it to us at the lowest price? It's just, what can we get for the lowest price? And then, and if you're a salesperson, the sales gurus tell you that's the last thing you want to market yourself on is price, because that's just heading down the drain. But yet, attorneys, and I've been at firms from 10 attorneys to 300 attorneys, and regional firms, and so it's not just one individual firm. I've seen this across the board where attorneys will, gosh, let's cut our rates. Oh, let's cut our rates. We can't collect this. Well, let's cut them a deal. And so dealing on this price issue, I think is really a problem for attorneys. So the obvious answer is, how do we demonstrate that? And a lot of times I've seen where entities will go with the low price leader, and then especially in litigation, a couple years later you get popped for a big verdict, and that price doesn't look so good as it does. And what is value? There's price and there's quality. And put those two together and you get value. So we're always trying to demonstrate our value to our clients and what our competitive advantage is with regard to that. And there's just as importantly is that when you're not really engaged with a client on a matter, is to be able to communicate what your continuing value is to them. And in this time of information overload by everybody, we all got our phones on our desk, and it's things buzzing continually, is trying to communicate concisely and effectively to our clients, what our value is at the right time, and not continually bombard them, with information. And again, the next thing I had was a cycle of risk, or in the zero defects mentality. I see this over the past 5 years. I've seen a trend or a cycle where in the past it was, settle it and settle it now, and then on the other end of that cycle is, by God, we're going to litigate this thing to the death. And our attorneys really pride themselves in realistic evaluation of a value of the case. Some say an aggressive evaluation of the case. But I remember distinctly this one partner traipsing up and down outside my office going, I can't believe they settled that for that amount of money. I can't believe they settled it. And so I think there's this cycle where after a while the companies get tired of just, somebody files a lawsuit, well, let's make it go away. At a certain point in time, some of these firms, some of the plaintiff firms, think that this is just an ATM that they can go to. And then on the other side, I think there was a feeling from the client side where, if I get popped for a big, settle it, because if I get popped for a big verdict, I'm going to have to go and ask for additional budget space. I'm going to have to ask for that budget variance, or I'm going to have to ask for additional reserve if it's an insurance company. And a lot of times since the Great Recession, if you can't estimate what that value of that case is, and you have to go ask for a variance, that could be your job. That's the zero defects. You've got to be right first time every time. So we've seen this, this cycle back and forth, and it's one of these tough decisions where we have two fold pressures. One, if they settle it, if companies or insurance companies settle early in the process, well, that's lost revenue for us. And then two, I think even a bigger thing is getting young attorneys into the courtroom. If we're settling early on, our attorneys aren't getting into the court. Our young attorneys aren't getting into the courtroom. We're lucky enough that we have a practice that are some lower cost or lower value cases where our young attorneys get into the courtroom, and they've done pretty well at it. So this is the pressure of trying to get through a case and in the most expedient way. Another thing is being a good attorney can hurt revenue. So my notes say more times than I can count, and literally this happened to me yesterday. I was walking down the hall, one of our partners came by and they go, we got out on summary judgment. We had this great argument, put a little bit of a spin on it, and we got out on summary judgment. And I'm like, dude, you're killing me in my revenue. It's like, can you be a little less outstanding? Just stretch it just a little bit more. I haven't heard litigation firms having a success fee like M&A does, but on the opposing side, I also haven't heard them giving back fees, when something didn't make. But talking about innovation with getting I was telling Teresa that I've seen one attorney in my 20 years with law firms correctly value a flat fee case or a flat fee proposal because they don't take into account all the assumptions that they don't state all the assumptions that go into this flat fee and what are the parameters that are outside that. But in any case, I see in the future that as we get better with budgeting, that maybe this might be something to do, is that we sit down, the attorney sits down with the client and says, what is the probability that this case will settle at summary judgment at this point, at that point, when it's going to go to trial? Because with this case, I joked with the attorney. I said, "You just, were part of my presentation tomorrow," and I said, "So if you hadn't gotten out here at summary judgment, where would this thing have settled?" He goes, "Oh, it wouldn't have. Their demand was so high and they were so crazy about it, it would have gone to trial." I said, "So you just lost me X tens of thousands of dollars?" And he goes, "Yes." And he goes, but I think that if we agree, if there's some collaboration here that says, kind of like an M&A deal, if this is where we believe the high probability is for this to settle, and that's the benchmark fees, and if it settles before or after that, then there's perks or penalties. So just something that I think that, like I say, we have a monthly meeting, and people will, they kind of joke now because when they say, "Oh yeah, we got this great result for our client," I'm like, "Oh, you're just killing me." And they go, "I'm sorry, Doug." It's like, we'll get another case for you. Similar to the bigger is not always better. Similar risk aversion. There's the old adage that you can say, nobody's going to get fired for, insert large firm name here, in case something, you lose at trial or a deal goes bad. Because I've worked for firms of various size in various regions, I know that, there are many attorneys who started with large firms, and for whatever reason, they may partner, but for whatever reason, they have decided to go to a smaller firm. And, at that point, some people say, "Oh, great, well, you can charge lower fees." I'm like, well, if they're doing the work over at, Abel, Baker, and Charlie firm, and everybody's satisfied with that cost, well, why would it be less at India, Julia, Kilo? It's what is the value of that service? And so the challenge for smaller firms, and I've seen this with smaller firms, is being able to compete for projects against the larger firms and firmly communicate, what their benefits are. Agility, or is it, personal attention? If you have to be in, if you're a small firm, if you're a 5 to 50 attorney firm that only practices in Ohio, and the company needs attorneys in 14 locations all over the country at the same time, and they need to be licensed in those states, well, yeah, of course that's not going to work. But I think that sometimes the smaller firms, and sometimes all that personal attention, we don't put it out there as a force multiplier. We've got to take away and the thought that somehow a detractor.
We're going to move to the pricing panel, but before that, we're going to have Dave Harrington from Plant Moran. He's going to do a little intro on pricing, and I think we dabbled into pricing a little bit earlier, which always happens, right? Because there's a lot of pressure on pricing. And one thing that I would like to point out when it comes to pricing real quick is that value is determined by the client, not the provider of the service. And so that's the thing that you really have to focus on when you talk about value, is who defines value, and that's the client. Dave, take it away.
Good morning. Dave Harrington, Plant Moran. I'm a partner for the last 20 years. I've been there over 30. Hopefully most of you heard of us. We're in Cleveland, we're in Ohio, Illinois, Michigan, a bunch of countries, and starting Monday we'll be the largest firm in Colorado. So we're over 3,000 people, so that's a little bit about us. What I've been doing, one of the things I do is I service professional service firms. It's been a lot of fun, and so I have a couple of niches there. I'm also on Slant Moran's board of directors right now, so it gives me kind of a big picture perspective on how things are going. I have one little quick thing. This is for all law firms or anybody that's a professional service firm. On the table over there, my tax guys asked me to this is tax reform implications of professional service firms. So if you haven't heard of how it impacts you, take one, bring it back to your CFOs or your COOs. And also the impact of meals and entertainment and fringe benefits on tax deductions. It's a big deal. It's changing in a big way. So if you work for a firm and you have to direct them how to spend their entertainment dollars, this explains the tax impact of it, which can change. It's a meaningful change. So just take them, hand them out, use them to level out a table, something like that. I'm going to quickly go through a presentation that I sort of updated from last year. So if you were here last year, I apologize for some of the redundancy, but I think it'll kick us off in pricing. And I apologize because I sent the wrong file, so you're going to get the slow. So the overview of the pricing panel here is we're going to look at pricing in a new and ever-changing world. This is kind of the bullet points. What are some of my competitors doing? How do I keep clients? What are my true costs on that matter? And then data overload. We've talked a lot about data, so that's kind of the overview. Go this way. Pricing and over. Many of my clients want to move away from time and materials. Some of these reasons include most of their other services are that way. So we heard from the firms that have in-house legal and they're buying services. There's very few services out there that are time and materials. In fact, when I started public accounting 32 years ago, 80% of all services were time and material and 20% were quoted. Now it's 95% is quoted and 5% is time and materials. And when I started, the noise from the partners were, you can't do things by time and materials. I mean, by quotes. It has to be time and materials. It's impossible. And so when I first started working with law firms some 25 years ago, 100% of stuff was done time and materials. That trend is not at 95%, but what I'm hearing now from a lot of my clients, a lot of the folks I do consulting with, you can't do that in time and materials well. I'm here to tell you the train has left the station. Other reasons, budgeting, we heard that. They want to have control over their costs. They don't want, your clients need to have a budget. They want to have control. They want carte blanche. They don't want to pay for training time. And this one's a big one. We heard this in the first panel about 8 different ways. Not perceiving value for the service provided. So this was an interesting stat, came from the Atwell survey. 50% of firms feel they do not provide a distinct differentiating value. So this is firms saying, we don't think we provide, we don't articulate what our value proposition is. We can't get it across to our clients. So if firms feel that they're not doing, about half the time they get it right, the reality is it's a much lower percentage from a consumer standpoint. So the ability to articulate, well, why would I pay time and materials if I don't know what the value is of what I'm doing? So there's value there. It's our ability to articulate it. Clients obviously want to get a better understanding of the scope, and at the end of the day, they want to be charged less. And so trends in pricing. So we service around 100 firms in the Midwest and throughout the country. And so I called quite a few, went through some surveys, and about, on average, I'll say like 20% of all fees are alternative arrangements, alternative matters, fee arrangements, and that's climbing. It's depending on the size of the firm. The larger the firm, it's there's more AFAs than a smaller firm. So it's not 100% of the fees, but it's not zero, and it's trending. And so what are some of the ways they're looking at it? Fixed retainer, annual fee. A lot of firms say, oh, I don't do any AFAs, but about half my stuff is retainer. So a lot of them view that as a time and materials thing because they set the retainer based on time and materials. Or a set fee per matter, which is what public accounting is kind of now. Breaking up the fee by a phase of an engagement, so clients are looking for that, or law firms are in an effort to gain work, are looking for that. Making the pricing in terms very clear to the client, providing options, providing price certainty, and firm estimates as best as you can. So this next one, managing change orders. That is the number one thing I'm hearing from managing partners, is they feel that that's a weakness of their attorneys, of their folks out in the marketplace. It's like, we've agreed to do this for X, and there's a change order, but we don't articulate it, we don't communicate it timely, and so then later on we're saying, well, can we bill for it? It's like, if you've agreed to do this transaction, this matter for $10,000, and they added on 3 things, don't tuck it in. And it's being able to have that conversation. It's not happening as often as it ought to. Then you're doing it afterwards, which makes people grumpy. And this is another one. Increased upfront two-way interaction with the prospect or client on setting the fee. So firms, it's like, we got to make this a conversation. Not, this is what I want, how much will it cost? It's actually, and we heard that from our panelists, how desperately they want the conversation. Like, we want to use you, let's have a conversation that can make it work. And we're on the other side as professional service providers saying, we want to get the best revenue for our firm, but it's like, but I want a long-term relationship. So if you don't build that relationship, you're not setting yourself up. But firms that are doing it are getting responses, are getting results. So what are some of my competitors doing? So they started to look internal, and this is increased a lot if you look at the trends over the last few years. So they're starting to look at their margins, not just their firm margin, but their practice margins, saying what makes money, what doesn't, what are the opportunity costs. Actually doing cost accounting, which was everybody's least favorite accounting class. It matters now because when we're sitting there talking about alternative fee arrangements, I got to know what profits I'm having. So 20% of firms are actually looking at it by by their practice groups. Maybe all of you are, so well done. The larger the firm, the more is being done. Over 60% of the firms are looking at the true cost of a service or a matter. The larger the firm, the more they're doing that. They're hiring cost accountants. And this was the most stark statistic I thought was like why we're here this morning on pricing. If you have alternative fee arrangements, 2/3 of firms are actually talking with their collaborating with their clients. How can we make this work? So that's a trend. So if you're recognizing you're competing, you have to give that. You're not talking to your prospects or clients. Likely, you might not get the work. I met a few hiring a pricing manager that is not an attorney. So I've met some this morning. Well done, firms that are doing that. It's been highly successful in what we've seen in our client base. Because candidly, there's a lot of accountants, partners at Plant Moran. We're accountants and we're not good at being honest with pricing. Attorneys don't even have a lot of that financial background that we have. So many of you are really bad at it, or your attorneys are great attorneys, bad at this. They need someone to hold them accountable. So I would say the firms that have this have seen that person, when they learn the ropes of your firm and your culture, they will pay for themselves. They will be hated at times. You'll get a lot of pushback. Your CFOs are going to get a lot of like, why'd you bring this guy in? He doesn't know my practices and my clients. He doesn't. Hang in there. Hang in there. It's well worth it. So that's what they're doing. And this other one, which I really think is huge, is training lawyers to talk about pricing with their clients and prospects. Like, so we train our staff on unbelievable skills, the business side of the business, like getting them in, and they don't want to be trained. And even my staff don't want to be trained about talking about pricing, because I went into accounting to do accounting, not business. No, this is how we make a living. So this is almost the price of entry at some firms that I work with now. You can't make partner if you haven't gone through this type of development, including pricing in the planning process. And again, it goes back to so these are what our firms are doing to respond to this. Linking the alternative fee arrangements to staffing and the way work is delivered. So if my price is $10,000, and normally in time and materials it would be $20,000, if I want the work, how am I going to do it? So how am I going to restaff this thing? Am I going to use leveraging? The larger the firm, the more these practices are being used. The smaller the firm, the less they are. A lot of times the small firms are kind of niched and can get away with not dealing with it yet. The larger the firms, they can't ignore it, at least what I've observed. So what are some of my competitors doing? They're attempting to figure out the real scope and put a price to it, trying to figure out if they need something, if the clients need something they haven't asked for. So this is value proposition right here. I think most of the new clients I get to work with, the question they ask isn't, I'll answer that one, but I add like 3 more questions to it. Like, what about this? What about this? That's providing value. So it's continuing to add, have an increased intellectual curiosity. Be very creative. Innovation was mentioned a few times. You cannot come back, because if they all look the same, there's no differentiations, and then it becomes a commodity, and then low price wins. An attempt to point out why you're worth more. Again, only 50% of the firms think they're worth more. So if only 50% of you think you're worth more than the guy down the street, that's going to be hard to differentiate yourself. And then leverage. I mentioned this a lot last year. So almost all the larger firms use some parapros, contract attorneys, part-time, outsource non-lawyer functions, outsource legal work, replace people with technology. And then here's the big one, reward efficiency and profitability. So if your bonuses for your attorneys are based on charge hours, guess what's not going to happen? Leverage. Like, there are so many firms under 200 attorneys where the major bonus is driven off of their charge hours. There's no way they're going to use any of these up above if they have to get their charge hours. Isn't happening, because that's my bonus. And especially if the bonus is a disproportionate amount of total compensation. So I've put in a couple compensation systems in the last year, and that's where we spent a lot of time. And it's not easy because of the big culture change. So a reminder on how to keep clients. Great work is the price of admission. Ask them how you're doing. Jeff mentioned client satisfaction surveys. So some of them don't have the time to fill it out, but so if you send one out, call them and ask them to fill it out. But better than that, when you're with them, just ask them. Tell me what we're doing. And if you sense someone on the team is not doing a good job, don't ask your client what that person is sitting next to them. I know that sounds funny, but well, other than Freddie's, you guys are great. Identify the value that you brought to them. This is a huge one. Because everybody in this country, including myself, has no memory anymore. We have like a 5-second memory retention. So if you did great work for them, remind them what you do. Like, I know it's kind of bragging, but we're all too busy to keep track of that anymore. And so that's a retention item. Continual contact, don't wait for them to call. We have a 14-day rule. If you have a major client you haven't spoken to in 14 days, you're out. They don't know that relationship is slipping. Evaluate each situation and determine how proactive you need to be in discussing pricing. So, again, don't wait for them to be calling you. On average, 30% of fees are discounted for firms under 250 lawyers and 50% for firms over 250. So know when you need to adjust fees and know when you need to push back and say, you're wimping out, and that fee that you quoted them 12 years ago probably should be changed. And so, the larger the firms get, typically their billing rates are higher. higher, so that I'd expect that percentage to be higher. So we don't have an alternative fee arrangement, we just bill them less. Well, sort of smells like an alternative fee arrangement. Internal, external, client service reviews, and then something law firms at times are very hesitant to do is introduce appropriate colleagues. You want more work in that place, you don't do real estate, you have a great real estate person, and then why don't they use the firm down the street for the real estate? Because you never introduced them, because it's my client, and it's not the firm's client. That whole mentality, building that trust that you can actually bring in colleagues, that you can service them. And sometimes the other term makes sense, it is working as a team. And then before we turn it off, so what, a couple, because I'm an accountant, what are the true costs? Our firms are finally taking a serious look at costing of serving a client, a matter of client industry. I've done more cost accounting consulting assignments in the last 2 years than I did in the previous 15. Like, what's my opportunity cost? We mentioned that things are growing in one area, flat in another. The reality is there's a lot of space where people are wasting money. Costing models are being implemented, looking at direct and indirect costs. So about 60% of the firms are getting serious on that. Leveraging work to the appropriate lower cost option. Again, if you're looking to try to optimize profits. Using your finance department to help analyze costs. So this is really a crazy thought. Your finance department might know something, hopefully. When we talk about the pricing director, this is interesting. Large firms are at 73%, small firms are at 15%. Identifying low realizing clients and responding to the opportunity cost. So I mentioned this last year. We have called the bottom 500. Every year we look at the lowest realizing 500 clients, and we determine if we should move the fee, move the client, or retain them because there's a strategic reason. And typically about a third of those clients, we get fee increases, a third stay the same, and a third we transition to another CPA firm and let them enjoy that event. Every year we make more money with the 2/3 we keep than the 500 that we had the previous year. Every year for the last 15 years. Fascinating. So if you're a larger firm, I just suggest that it might be maybe not that large, maybe take your bottom 50 and take a look. So I'm just going to point, there's a lot of data out there. I really do like the Atwell. I think that's the best survey. Oh, yeah, by far. Probably a lot of you participate because over half the...
We think ours is better.
I haven't seen yours. Jeff will send me his. Then I'll say, man, Nimble's is better. But this is the key one here. Pay attention to trends. So there are anomalies, like if you see things heading this way, at Plan Moran, we like to call ourselves fast followers. So we don't want to be the first ones off the boat. We want to make sure the boat's already safe and seaworthy. Then we try to jump on it. Because we just don't want to make that huge financial investment until we know it's worth the investment. But we stay very close to trends. AI is a big one. You hear that a lot. So we're beta testing AI software to read documents for audit purposes. Because not the Big Four is doing it. Can't look because the Big Four is doing it. So we sort of watch what the Big Four do, and then we just sort of stay behind. We're not into the legal industry. We've stayed away from that. Our insurance is not worth it. But watch the trends. Don't ignore them. But don't get so consumed in trend or in big data that you don't get work done. It's still a trench warfare industry where it's client matter by matter, client by client. So if you govern by data entirely, your attorneys will get turned off, just like CPA partners do get turned off. So with that, we'll turn it over.
So Dave, thank you. Panelists for the pricing strategy, Dave Harrington, Bill Carino from Swagelok, Charlie Price from Eaton, Louis Dolezal from Scott's Miracle Grow, and Mike Goldberg from Thompson Hine. Dave, one thing from your presentation about the efficiency and time to charge hours, I think one of the things that we are trying to accomplish with our forums is to talk about the business of law, and I think what a lot of law firms do is a bit of a disservice to their associates in not training them on the profitability of the work that they're doing. So tying all of their bonuses and all of their targets to just hours billed, you're not teaching them how to actually work in the business of law. And I feel like you're doing them a disservice. That's my own like PSA right now, so off the soapbox. And we'll start with our panel. So Phil, you're up first.
Okay, I'm Phil Carino. I'm general counsel at Swagelok. I grew up in town. Came back after law school, started my career at Calvin Halter in Griswold, and I was there for 9.5 years. I made kind of a strange move about 5 months after making partner. I left the firm, which is a little unusual, and it's not a statement about Calvin at all. I just had a very good offer from GE, and I moved over to GE. I was with GE for 16 plus years in various businesses: the lighting business, electrical distribution, power, water, motors, air quality, a number of different businesses. And after being at GE for 16 years, I moved to Swagelok. I've been at Swagelok for not quite 2 years. I started on Halloween of 2016. And when I started, I actually got a little bad information from someone. They told me that everyone at Swagelok wears costumes on Halloween. So a little bit of an awkward first day, but I think I've come back from that. And so things have looked up since then. But as many of you know, Swagelok is based in Solon. It's actually a fairly good-sized company. We have over 5,000 employees, a couple billion in sales. But I wanted to go off script a little bit and talk a little bit about the difference between working in a GE from a pricing perspective and working at Swagelok from a pricing perspective. You know, GE is a company with over 1,000 lawyers, an outside counsel spend of hundreds of millions of dollars a year. And Swagelok, we're in terms of lawyers, we're single digits, and our spend isn't quite hundreds of millions of dollars a year. So there is a little bit of a difference in that regard, and I think firms do look at you a little differently. I don't know, though, of any firm that would look at Swagelok, a good paying client like Swagelok, and say, we're not interested. That's definitely not the case. But GE is a little bit different because, you know, if we have a matter in Minnesota, a Minnesota firm probably is going to like to talk about the fact that it has GE as a client versus Swagelok. If you're in our industry or if you're in town, you know Swagelok. If you're in Minnesota, you might not. And obviously, in terms of the volume of services that GE requires, that can be fairly attractive for a law firm as well. And at the same time, Swagelok has a lot going for it. We pay our bills. In many ways, we're much easier to deal with than GE, and you know, I can certainly attest to that. You know, we're still at the scale where a law firm can email an invoice to us. We don't make them sign on and pay a fee to go through some billing program. It's a little easier to just deal with us on a day-to-day basis. And so we do have a lot to offer, but I do think firms look at us and GE differently. And that does affect pricing. It does affect in terms of alternative fee arrangements. And another factor that weighs into this is we are a small legal department. We kind of have to do everything ourselves. At GE, they have people, they have lawyers whose job it is to cut deals with outside counsel on a global basis, on a national basis, preferred provider arrangements, and also have the freedom to look at different ways of billing and come up with new and innovative arrangements in terms of price and cost. So there is a big difference between a company like GE and a company like Swagelok. But from my perspective, the motivations really are the same. We're looking at value. And you know, price is a very important part of value, but it's not the only consideration. So you look at a lot of different things. When you're looking at an hourly rate, for example, I don't know anyone who wants to pay a $200 an hour lawyer to do something in 4 hours where they could pay someone $500 lawyer, $500 an hour lawyer for 15 minutes of work to do the same thing. So you really have to look at the value that's provided. Staffing is important. That's an important component of cost. Budgeting is a big tool to manage costs. And in budgeting, it's often good either to set a hard budget or in some cases to set a cap. Now, obviously the problem with the cap is it ends up, that the fees often end up being at the cap. So when you set a cap, you have to keep in mind that you're really setting a baseline. One other area that I wanted to talk about is in terms of looking at law firms, we often look at them from a sourcing perspective, just the way our sourcing department would look at acquiring materials. Now, it is very different than that in some respects, but often in a big company, you do have to deal with the sourcing department. I have this less at Swage Lock, but I've had instances where I've got a little niche project, very important project, but not a lot of lawyers have an expertise in that area. And I find the perfect lawyer for it, and I go to the sourcing department and say, I need to set up this law firm. And they say, okay, you need 3 bids, you need have them fill out this vendor information sheet, which has a bunch of irrelevant information. So you do have to manage the sourcing people when you're in a bigger firm as well. But it's the other area I think worth talking about is the billing area. Oftentimes we have situations where you have a large matter, and it's important to keep in mind that you can negotiate as things go on. Sometimes a matter ends up being bigger than you expect. And if you've got a fixed fee for the matter, you do have to take that into account. You do have to be flexible on both ends. And in that regard, I think one thing we do that's probably a little different than a lot of companies is we do use retainers a lot, the subscription model quite a bit, where we negotiate with the firm that they will provide certain legal services over the course of the year for a fixed fee. And a lot of firms and a lot of companies don't like to do that because you are taking a risk that you're going to get it wrong, you're not going to price it right. But there are a lot of advantages to it too. The finance people like the certainty that comes with that. And then at the end of the year, you can always readjust. You can always figure out how much work was done, what kind of value did you get, and did you win or lose, and then make adjustments as appropriate. We've been pretty successful with that. What the types of matters that lend itself to those types of arrangements tend to be repetitive matters, matters that are a little more routine, but you can also use them in a broader arrangement where you're just going to provide legal services for us for this amount. We're going to call you up, and you may keep track of your time, but we're going to pay this amount. And we've used that pretty successfully, actually. And both the firm and the company do have to readjust after on an annual basis, essentially. But I find that it makes it a little easier for us to raise issues that we might not raise otherwise because we don't want to pay for a phone call. So we'll raise issues with the firm. And I think in the end it works well with the firm because they have certainty on their end. They know how much business they're going to get for the year, how many people they may need, and I think it works for the benefit of both parties.
Yeah, they've got revenue certainty, and those kinds of arrangements work really well, but there has to be trust on both sides of that equation. If there's not the trust, it's not going to work out. All right, Charlie.
Good morning, everyone. My name is Charlie Price. I'm an attorney at Eaton Corporation. I've been there for about 2 years. Prior to that, I was in private practice for about 20 years. And 2 years ago, I had the opportunity to join Eaton and help them with their litigation management, which was a great opportunity, and so I joined them. I also teach at the University of Akron School of Law. I teach a class in litigation decision analysis. This is a great, I'm passionate about this topic. I find it fascinating. I talk about it more. I'll keep my comments as brief as I can. I think that there's a lot of discussion. If you go on LinkedIn, you'll see things about alternative fee arrangements and the hourly models, debt, and all that stuff. At Eaton, we use both. We're still hourly model heavy. But we use both. But really, the challenge with the model for us and for, I think, our law firms is that with the hourly model, if there's inefficiency in the process, then we bear the brunt of that. And if we have an AFA and the firm is inefficient, then they bear that risk. And the problem is that if they're unhappy with the arrangement, then we're negotiating. It damages the relationship. And also, I think it probably, in the litigation context, it damages our defense or our representation in some way that we might not see. Because if you pick up a file and you're unhappy about the deal that you made, or you feel like you can't do everything you want to do, I think that impacts us in some meaningful way, although you can't really record it. So I think informed agreements, whether it's an hourly model, it's an AFA, it's a cap, something is important. That gives you as a firm the flexibility to compete on many different levels and be in whatever the rate model is, you can differentiate yourself, to Dave's point. And with there's 1.3 million lawyers in the United States, I think, and 40,000 plus law firms, and that's a big thing for firms, is how are you going to differentiate yourself? How are you going to be a 1 in 1,000 firm or a 1 in 100 firm when you go and you market yourself to clients? I think it's hard to do, and that's the challenge. I think doing it, though, starts with something that Dave brought up, which is you have to learn math. We have to know cost accounting. You have to understand not only your firm metrics, which is what law firms focus on. They focus on those metrics, the billable hour, revenue per attorney, how much expense they're incurring in each practice group. But you have to go beyond that. And the same is true for law departments. We focus on case metrics, total spend versus revenue, all those things. But we have to get deeper, because in the litigation, particularly in the litigation context, the equation is a little more complicated than that. It's what are we spending our money on? As a law firm, what are you going to spend Eaton's money on? What are you going to buy with it? And how much is that worth? And so built into that is there's forecasting, there's predictive analysis, there's analytics. Not only analytics in terms of how much it costs you, the law firm or the lawyer, to do the task, but what is the value of that task to get us improve our negotiated or litigated result, whatever that is. And in most cases, in the overwhelming number of cases, it's probably going to be a negotiated result, which means that doing everything in a piece of litigation as a law firm isn't going to work, because you're playing the hand, not the odds. The odds say we're going to get out of the case at some point, and it's going to be resolved. And so we can't do everything. And our lawyers can't do everything. We don't want to pay for everything. So what we have to do is we have to figure out, okay, what are the most valuable things that we can purchase? The summary judgment motion, for instance, we might have a great legal argument, but if our law firm doesn't know the judge's tendencies, whether he or she will ever grant a motion for summary judgment, or when she does, what cases, in what types of cases, or what case law does she rely upon to make that decision? If you know that, then we can make a better decision. But a lot of times when we say, oh, we have a good chance of winning this motion for summary judgment, we should spend money on it, it doesn't have anything to do with that data. It has to do with a firm's ability. What they're really saying is we can write a good motion for summary judgment because we're really smart and we know the law and we're really good writers. But the value, if the court's never going to grant it, then the value is zero to us. It doesn't do anything. So that's the kind of metrics and analysis that we need. And so we all need, in-house counsel and outside counsel, need to know what are the metrics, what are the key variables in whatever we're doing that control the cost and shape the result. And so focusing on that requires doing things that lawyers don't typically do, which means you do cost accounting, you do forecasting, you do probability analysis, you have to learn some statistics and things like that so that you can demonstrate value. And I think that's a differentiating principle for law firms. I think if you can do that, you'll be way ahead. At Eaton, we have lots of firms that come in and talk to us about what makes them different. And a lot of times when you ask that question, if your firm packed up in the middle of the night, what would we no longer be able to get? And there's not, a lot of times there's not great answers to those questions, but ways you can do that is to, embrace some of the things that Dave said about the cost analysis and all, and those kind of non-lawyery things. And the last point is that it's hard, and but it's continual improvement. We're we do better than we did yesterday, and you don't have to have a massive, how do we even start, whether you're an in-house lawyer or outside lawyer, it's making small things, understanding what your cycle time, your how long your litigation lasts. We had a law firm that comes in and says, well, in Cuyahoga County, it takes 14 months for a case to get from beginning to end. And we looked at our results, it takes us 11 months. And so for the hourly model, that means 5 months of not paying fees. So there's little things that you can do to start to build that up. And it's, luckily for me, it's more a matter of spirit than intellect. And so we can all do it. We just have to shift our focus a little bit, be creative, harness kind of the diversity of thought within your firm to figure out how to do better.
Thanks, Charlie. One thing, every law department, law firm is at around a different maturity level when it comes to metrics and how you look at data and things. And here's a little plug for us. We published a blog post on the 19 legal metrics that matter. So if you go to our website, you can find that there. It works for both law departments and law firms. It's a great place to start. It's more high level. It's not digging into some of the deeper stuff, but you can't get to the deeper stuff until you're doing the basics. So go check that out, and if you want help with that, we can obviously help you with that. Thank you, Charlie. All right, next up, we have Louis.
Louis Dolezal, I'm a counsel with Scott's Miracle Grow, and Scott's Miracle Grow is a local consumer products manufacturer, mainly focused on consumer lawn and garden. We went through a acquisitive period of time, so under our Hawthorne companies, we focus on hydroponic growing and indoor gardening solutions as well. And across both businesses, we're emerging with IoT products and technology solutions. And what I counsel on at Scott's is generally commercial and corporate matters, some bit of a generalist on a subject matter basis. I counsel on customs and privacy-based security and technology transactions. Prior to doing that, I supported real estate before we divested from Scott's Lawn Service, which was a service provider and franchisor of lawn services across the country and bits of Canada. So a lot of what I'm going to talk about is colored from a commercial context and engaging commercial partners and outside counsel from that perspective. And really my first point is when we engage a firm to be a strategic partner, one of the things, the exercises I would like to go through and talk about is not all matters are created equal, and especially in the commercial context. And there's this old project management model of trade-offs where you talk about if you want a deliverable or a project delivered, and in this case legal services, there are three drivers. One, value, and as far as the cost context. Speed of delivery, which is very important in my business, where we're a consumer products company and we have a lot of seasonality. And then expertise or quality. But the catch is you can only have two of those. You can't have all three. And that's somewhat of an oversimplification, but I find it true in a lot of cases. So when you think about the bucket of work, or the buckets of work we have, and the work that needs to be done, we think about those trade-offs. And when I'm talking about commodity type work, so I support supply chain, which is a big bucket of work. It needs to be done. It's not something we can really push down in a lot of cases, but it doesn't really require a lot of expertise. So what I care about there is value as far as cost and speed. I expect that to be priced differently than strategic matters. So if I'm working on an antitrust or competition matter, I very much care about expertise. I very much care about speed, usually the circumstances require it. In those cases, I'm not that concerned about economic value or price. In those cases, it seems to be reasonable to pay more above market for that kind of advice. And the third bucket, when we talk about I need value and I need expertise, long-term partners, you can structure these are more amenable to more programmatic counseling or training, where you do expect to tap counsel from time to time on a very regular basis. I expect some kind of value there. I expect some kind of expertise, but I'm not really worried about speed that's required emergency staffing. So using those typically drives, you know, a blended fee arrangement with more commodity type work, where I can predict it better. Your market pricing, and then your fixed fees for the buckets of work that are valued, you need expertise. And generally, when considering those three drivers, those three types of ranges, we can arrive at a price point that makes sense for the company from a budget perspective, but also being sustainable for our outside firm that we want them to thrive with us as well. So when you're considering an engagement, I feel it's very important that you think about what position are you in the engagement? Are in this context, are you a commodity provider for this particular engagement? Or think about your expertise. I think part of that will drive pricing. My second takeaway is, and I think Hillary in the first panel did a good job of hitting on this point, and I picked this up from supporting some friends in purchasing and sourcing. It's total cost of ownership of acquiring something. So we can negotiate a really favorable blended fee. It's really low, or you're really excited. But if it costs me 2 hours of internal time to turn your advice into something that's usable, that's a problem. And from time to time, I'll actually track my time, or if I have admin time allocated to that, to fix a red line in an agreement or whatever. That lower blended fee doesn't seem all that attractive anymore. And just be cognizant of what deliverable you're giving back. Usually there's me and another business person on the other side of that, and I have to translate that. If I'm spending too much time, I'm going to calculate that to what I view as the price, because internal time is up at a premium for in-house counsel. So the price is not always the price. It's getting that cadence and usability of product. And boy, I can tell you, it's getting easier to digest and consume your work product. That's a whole other set of value that can be part of the calculus. And then lastly, I call it the proactivity premium, and I deal a lot with technology, so it's particularly relevant in this space. But many law firm partners are coming up with either productizing their solutions, offering solutions on a continuing basis. If you can combine cross-functional thinkers as part of attacking particular problems, and I'm not talking about these lunchtime CLEs that you invite your clients down to, but really getting to a meeting workshop, whether it's technology or some other issue, to create kind of a think tank. In technology, there's firms that do a great job of surveying the technology landscape and really giving an unbiased view. And if you could tell your clients, this is what I'm seeing, this is how it's being implemented, I think that's a huge value. And being proactive about knowing who your client is, what's going on in the news, and how they're developing. It sounds cliche, but if you could meaningfully do that, I think that's a differentiator. All things being equal, we have an outside partner that knows the business, is doing those activities, is proactively reaching out. Naturally, it just drives engagement. There's a halo of value around that partner as well that could help turn a decision on who gets what work. So I think that's not to be underestimated.
Thanks. Okay, Mike.
Thanks, Jeff. Thanks to you and Elizabeth for giving me the opportunity to be here. I appreciate it. I'm the Chief Financial Officer at Thompson Hine, been there 14 years. It's my third law firm,
Sort of like your third wife.
one wife, 3 law firms.
Good choice.
Prior to Thompson Hine, I was at a firm out of Philadelphia called Wayne Morris, about 800 lawyers, 20-some offices. And I was there about 4 years, and prior to that, I cut my teeth in the legal industry at Jones Day, and I was at Jones Day for 7 years. Thompson Hine is the first firm where I've had a lot of experience in alternative fee arrangements and pricing. And although we did profitability analysis, which is something I'd like to touch on at both of the previous firms as well. So I did hire a pricing, now she's a senior manager who's very intimately familiar with the legal industry, an excellent analyst, financial analyst, and accountant, is able to data mine the data that we've got in our system to a large extent, and look at similar matters and help price an engagement. So she's been invaluable and has saved me tons of time from the standpoint of, you know, where the heavy lifting occurs. Thompson Hine also fairly recently hired a chief innovation officer. I think some of you might know Bill Garcia. I think he's been at this forum. And Bill, we've been talking about innovation strategies and software that's out there and change that is occurring, that many people say has occurred in the legal industry. And Thompson Hine is trying to be at the what did somebody say, the following edge, or not the leading edge, but right behind it. But we definitely think there's value in you know, excellent legal service is the price of admission, but there's you know, how do you differentiate yourself, right, Charlie? And innovation is a key way that we do it. Another key way that we do it, and I'll stop with the commercial, is knowing our client, and that comes out of our client service pledge. And you know, obviously there's an inherent tension between in-house and out-house. I love that counsel, and pricing is where those, you know, where those things come together. The best way to bridge that chasm or that tension, I think, is communication. And if I can only put one word up there, it would have been communication. I think that's such a key element in so much of a business, but particularly where there are two entities, two organizations that are at odds. You know, time was, before the 70s, my understanding, was that law firms issued a one-line bill for legal services rendered. And then sometime approximately in the 70s, clients demanded more transparency, more detail, and we went to this hourly billing model. And now we've gone to electronic billing, where clients can use software to pick apart every hour and disallow expenses, which puts the onus back on the law firm to then go back and try to justify those expenses. The third party providers, not even to the client, to the third-party providers of the electronic billing. So there's a lot going on there. But the best way, I think, to achieve both parties' goals is to have effective communication. What is the client looking for? Are they looking for the overall lowest price? Are there budgetary restrictions? Are there budgetary restrictions this year but not next year because they're at the end of the year? Or is predictability what they're looking for? And do they really want a fixed fee? We try to avoid cap or not to exceed fees because there is no upside potential for a law firm. If it's a not to exceed fee, you get the lower of actual or the cap. Whereas if it's a fixed fee, there is an incentive for the law firm to manage that effectively and eke out our cost plus, or maybe even a premium. When we're not as familiar with the client or not as familiar with the engagement, we frequently will talk to the lawyer or the client about using a fixed or flat fee with a collar arrangement. And I think Phil, you had mentioned that you know, the risk transfer that happens with a fixed fee goes from the client to the law firm. And sometimes the law firm is just not willing. They don't know, they don't have enough information to accept that risk transfer. So a method that we've used successfully is a collar. For those, I'm not sure how many people are familiar with that concept, but a collar might be 10% up or down. So the fixed fee for the engagement is $100,000. And then you track the actual time value of that engagement. If it comes in, if it's a 10% dollar, if it comes in less than $90,000, you start to either refund or credit the client back for all the dollars less than 90. If it's over 110%, you're entitled to bill the client for that overage. So it limits the risk to the law firm, and provided that the law firm has to substantiate those hours to the client.
Nurses have call that fixed fees with training is.
It's a good term. Yep. We've used success fees successfully. From an accounting standpoint, if it's a merger or an acquisition and it's a broken deal that never goes through, the client is going to have to expense those fees in the current year. They'd rather pay less for that. If it's a deal that does go through, they may be able to amortize those legal fees over a longer period. So that's an example of knowing what is important to the client and working with them and play into how the deal is priced. Sometimes clients are less concerned about price. Maybe they want a quick conclusion. Maybe you need to work all weekend. Maybe you need to work 5 weekends in a row. They don't care, and they'll pay you for that. They just want it done. And that's the important thing, is the business reason to have it done. Sometimes maybe it's the lowest overall cost. And we've had many discussions where clients are interested in alternative fee arrangements, curious about them, want to talk about them, and end up asking us, would you take X% off your rent rates? Could we have a discount? Which obviously doesn't help us. It's hard to dig our way out of a discount. We will talk about a volume discount, which I think is a great way to incentivize the client to give us more work, and in return, we'll give you a larger and larger discount the more work you give us. So those are some additional examples. I'm going to try to not be redundant since we've had 4 people talk about pricing already. I think, Jeff, you mentioned about it's very important that it's not your perception of the matter, but it's the client's perception of the matter. Well, how do they view the value of this matter? And that's what is going to drive, in their mind, what they're willing to pay for it. I think we covered a lot of that and how that would affect pricing. We talked about risk transfer. My second bullet point is a work plan or a budget. And this is such an important tool for so many reasons. Your plumber may be able to come in and say, I can do this for $2,000 and give you a flat fee because they've done it so many times, and it's a relatively low risk for the plumber. But certainly if it's litigation or a major transaction in many different areas of law, the lawyer is very well advised to go through a detailed work plan of what exactly is involved. That'll force the lawyer to think, is there tax considerations? Do I need to talk to my tax partner about what his costs might be or how many hours he might have to devote? It really forces the lawyer to pick apart the engagement, anticipate where things might go wrong, and more accurately price it. And it may be a fixed fee that the client is looking for, or maybe not. But in any case, you should be able to give the client at least an estimate of what you think this will cost, so the client can decide what, maybe it's already your client, you already have the deal, you're not bidding for it. But I think it's important that both parties are on the same page as to what expenses are anticipated. So it forces the attorney to think through each element of the engagement. It's also a great marketing tool for the outside client, the outside counsel when they're talking to their client. You can data mine similar engagements. You can talk to the client about how many times you've done this, what have you done, where you have seen it go off the rails. You can talk about your assumptions, how many depositions it might be, or whatever the assumptions are. And you can demonstrate to the client your experience, your expertise, how well you've thought this through. And I think any client is going to be interested in that. So I'm going to move on to pricing options and business terms. So we talked about the options. What I think is helpful and what I've seen used many times is not going back to the client with, well, here's your fixed fee. here's a fixed fee, or here are our rates, take your pick. Give them some options. Here's a success fee possibility, whatever it is. The success fee could be, you need to have triggers to determine when that success fee kicks in that are very specific. The scope needs to be specific, which you would cover in your work plan. I've even seen a subjective success fee in an engagement letter. Client, if you like us and you think we're worth it, please consider a bonus, if you will, or a success fee. And where the relationship is good, I think that works. I think it's important to define the billing and the payment terms. There's been more than several times where the understanding on the client side is, well, we'll pay you when the deal is done, and that the law firm never learns that from the partner maybe, and I'm hounding them to get the bills out. We can't bill this until the end of the engagement. That should go into the pricing calculus. If we're going to be the bank, if we're going to hold on to that money, we would like to know it. There are situations where the client, if the deal doesn't go, if it's a financing deal and they don't get financing, they might not have the ability to pay you, and which makes that a contingent fee. Certainly like the ability to approve any contingent fee beforehand rather than after. So it's important that the business terms are talked through. And then I've got communicate again, ongoing. It's really important that communication stays front of mind. Jeff, you mentioned 14 days. Am I running out of time?
Yes, I'm sorry.
Okay.
We're going to have to cut you off so we can end here on time. Thank you very much.
Okay, thank you.
Are there any questions for the panelists? Yes.
Thank you to both the
Go
first panel and second panel, but one thing that I did not hear, but we're kind of dancing around it, with mitigating repetitious matters and with managing internal volume. Have you considered a macro level solution like legal project management, something that's gaining steam in the industry where you can engage a firm and manage internal headcount through engaging an outside firm to become that internal person that you can just pick up the phone and call, or I don't want to commoditize legal services, but for the repetitious matters, it is a possibility of having a macro level solution. That you can use that.
Yeah, I think that's a form of a subscription model, actually, to some extent.
I mean, it includes your retained, your AFAs. It just it mitigates your internal headcount if necessary. If volume volume keeps going up and you just don't have the heads or you need to cut heads. It's just something that's gaining steam after
Legal ops.
Yeah.
And so we love what you're saying, because that's a lot of what we do.
There you go.
All right, other questions? All right, one question for you guys panelists. Is time really an actual good measure of value? So Mike, we'll start with you.
It's not the best measure of value. Unfortunately, it is the best measure that law firms have to measure productivity of their lawyers, and that's the rub. And law firms need to figure out a way to get away from that, and few have. But it's time does not equal value. Certainly not.
Charlie.
I have mixed thoughts on it, but I don't mind. I don't mind it being. I mean, I don't think the time. What's the result of the time is what's the value. But the thing I like about the hourly amount is I can see what attorneys are doing, and I can gauge whether they're getting it, whether they understand what a win is in a particular case. And so it gives me a lot of transparency. And the other thing, this is for younger lawyers, a lot of times the only contact you have with a client is in the time that you put down in your billing entries, right? We've hired lawyers who we never interacted with on any meaningful level when they left firms, because we saw what they put in their bills, how much they spent, and how they spent their time. So if you're not managing the relationship, that the time you spend is an incredible marketing opportunity for them.
All right, Louis.
I would echo that, because that oftentimes the review goes most of this months after the service was rendered. So it's very helpful in reminding of value, even how you write your reviews. But I would kind of echo what the two comments. I don't particularly think it's the best, but I haven't seen anything better in his terms of measuring and then being able to predict on the inside what a project should probably take. It's just, I think it's a common denominator for staffing, and then being able to bring in what our resources require. So I have to say,
All right, thanks. All right, Phil, let's get controversial here.
Well, I actually agree with the others in that time, I don't think time is a perfect measure. There is some rationale for it, but there's just not great alternatives right now. It is difficult. You take some risk when you settle on a fixed fee or some other arrangement. It's worth doing, it's worth looking at, but with time, at least there's some very specific rationale. And I'll also echo that having transparency in how the lawyer spends his or her time is important. When you're looking at in-house, when you're looking at an invoice and you see somebody write one line for 4 hours of work, you look at that differently than somebody who has 3 hours of work and writes about 10 lines worth of description of what they're doing. That kind of transparency goes a long way to communicating your value.
It's also a little bit of marketing. Okay, I'm going to bring Elizabeth up here, but if you guys could answer this last poll question, then we're going to let you go, I promise.
So why don't we give our panelists a round of applause. All right, well, we're just a little bit over time, but hopefully you were able to get a couple of great nuggets from all of our great panelists today. I think you can see they have just a wealth of experience. Usually we like to be a little more interactive, a little more Q&A, but I think we got some great content just the same. So before we let you go, just a couple minutes late, I wanted to give you a couple of heads up. One, expect an email as a follow-up to this event coming from Nimble. You'll get a survey, so you can give us some feedback on how you thought the event went, and also link you to some resources from the event, so notes, slides, things like that. So keep your eyes open over the next couple of days for that. And then just wanted to tell you about a couple things that Jeff and I are excited about going on at Nimble. One is, if you are interested in this topic, you're here, so I assume you're at least somewhat interested. We are planning a bigger legal industry innovation forum for March of next year. So if you are interested in being a panelist, featuring something that you're doing, or suggesting a topic for us to cover there, please reach out, because we are looking for panelists and ideas and things that are really happening out there in the industry that are innovative. So please reach out on that. And the other thing we're really excited about is our partnership with Legal Sifter. Mike in the back, give a wave. So we are an implementer and reseller of an artificial intelligence contract review software that we're really excited about. So we're just getting started with some engagements there. Really neat piece of software that we think can have a great impact for some of our clients. And if you can't get enough of Jeff and Elizabeth talking about stuff, we're going to be in Austin in a couple of weeks. Speaking at the Association of Legal Administrators Conference on Lean for Legal and alternative sourcing and resourcing strategies. So if you can't make that, we'll be in Grapevine in March. So thank you all so much for coming out today. Keep your eyes open for that email and register for our future events. Thanks, everybody.